As a business owner or employer, you are required by the Work Health and Safety Act 2011 to consult with workers who may be directly affected by a health and safety matter. When you share work health and safety duties with another organisation, duty holder, business owner or employer, you must consult, cooperate and coordinate with each other and any workers of the business. This can include labour hire organisations and contractors. Workers must have an opportunity to express their views and contribute to any decisions relating to their health and safety. For instance, any change to equipment, even for risk control purposes, must be discussed with workers before the change is made. Workers also need to be involved in any conversation about the adequacy of facilities. As an employer, you must consult when identifying hazards and assessing risks, making decisions about ways to eliminate or control risks, changing or updating workplace facilities, proposing changes that may affect the health and safety of workers, making decisions about consulting procedures, resolving safety issues, monitoring workers' health and conditions, and providing information and training. You also need to consult, cooperate and coordinate activities with other individuals and organisations, and any health and safety representatives or committees who have a duty in relation to the same matter. Consulting with workers will help identify problems and issues before they escalate and can assist in reducing work-related injuries, illness and diseases, which could save your business time and money. There is considerable evidence that effective participation of workers and the representation of their interests in work health and safety issues are crucial elements in improving health and safety performance at the workplace. Effective health and safety consultation also leads to greater awareness and commitment because workers who have been actively involved in how health and safety decisions are made will better understand those decisions. Consulting with workers also promotes positive working relationships because understanding the views of others leads to greater cooperation and trust, and all of these outcomes are good for your business. Consultation can occur by using any or all of the following: health and safety representatives, also known as HSRs, health and safety committees, also known as HSCs, other arrangements with your workers, which include but aren't limited to toolbox talks, regular scheduled meetings where health and safety matters are on the agenda, one-off meetings, briefing sessions, online meetings or discussions including video conferences, and face-to-face discussions. There's some flexibility in establishing consultation arrangements to best suit the consultation needs of the workers at your workplace, be it regular toolbox talks or scheduled meetings with their HSR or Health and Safety Committee. Today we are going to talk about how this representation occurs through HSRs, who are elected by workers to represent them in relation to health and safety matters at work. The number of HSRs to be elected at a workplace is not limited by the Act, but is instead determined following discussions between workers who wish to be represented and the PCBU for whom they work. The process for electing HSRs is initiated by a worker's request. The request does not have to be in any particular form. Where one worker of a PCBU at a workplace requests the appointment of a HSR, the PCBU must commence the election process. One of your workers may request that a health and safety representative be elected to represent them or other workers on health and safety matters at the workplace. If you receive such a request, you as the business owner or employer must facilitate the formation of at least one work group for the HSR to represent. The worker's request triggers the PCBU's obligation to facilitate the determination of one or more work groups, providing the worker's request is sufficiently clear. A PCBU is required to facilitate the election of HSRs. Facilitating the election process requires a PCBU to adopt a supportive role during the election process rather than a directive one. All workers of the work group must be given an opportunity to nominate for the position of the HSR and to vote in the election. The purpose of dividing workers into work groups is to facilitate representation by HSRs in relation to work health and safety matters. The legislation does not limit the determination of work groups and clarifies that a work group may span one or more physical workplaces. Work groups must be negotiated and agreed between the relevant parties. A workers' representative could be a union delegate or official, or any other person the worker authorises to represent them. All reasonable steps must be taken to commence the negotiations to determine work groups within 14 days after a request is made. Anyone from a workplace can nominate to become a HSR, and once elected, they represent their work group on health and safety matters for a term of office lasting 3 years. They are also eligible for re-election. The work groups are established first through consultation and agreement between the business or employer or other PCBU and the relevant workers. Then nominees are called and an election is held. Health and safety representatives are elected to represent workers in a work group on health and safety matters. The relevant PCBU and workers of the work group must be advised of the results of the election. Health and safety representatives facilitate the flow of information about health and safety between the business or employer or other PCBU and the workers. They monitor the health and safety actions taken by the business, investigate workers' complaints, and look into anything that might be a risk to the health and safety of the workers they represent. If a HSR has completed an approved HSR training, they can also direct unsafe work to stop when they have a reasonable concern that carrying out the work would expose a worker to a serious risk. A direction to stop work can only be given if the issue has not been resolved by consultation, unless the risk is so serious that it's unreasonable to consult first. HSRs can also issue a provisional improvement notice when they reasonably believe there is a contravention of the Work Health and Safety Act 2011. However, this requires that they have attended the 5-day training. A HSR is entitled to attend the approved initial 5-day course and annual refresher course of their choice. Additional training may be undertaken where it is agreed to by the PCBU and the HSR. It is not mandatory for HSRs and deputy HSRs to be trained. However, if they request training, they are entitled to attend. HSRs and deputy HSRs should be encouraged to take up their training entitlement to provide them with the skills and knowledge to perform their role effectively. As I said earlier, HSRs can issue PINs and direct work to cease only if they have been trained. Untrained HSRs can perform all other functions. Once their request for training has been made, the PCBU must allow them to attend the approved training course of 5 days. They are also entitled to attend a 1-day refresher training each year following the initial training. The approved course must be approved by the regulator, which is Safe Work New South Wales, and be chosen by the HSR in consultation with the PCBU. HSRs are elected to represent workers on health and safety matters and have responsibilities and protections under the Work Health and Safety legislation. It is a serious role and has powers and responsibilities under Sections 70 to 74 of the Work Health and Safety Act 2011. The HSR and Deputy HSR have a pivotal role in information gathering through consultation, observations and research on what the work health and safety issues are for the work group and how these might be resolved. HSRs can work with managers, supervisors, and where they are part of consultation arrangements, other HSRs and or the Health and Safety Committee. If a HSR has completed the approved HSR training, they can direct unsafe work to stop. This stop work direction can only be given if the issue has not been resolved by consultation, or if the risk is so serious that it's unreasonable to consult first. as well as issuing a stop work direction, a HSR can issue a provisional improvement notice, otherwise known as a PIN, if they believe there is a contravention of the Work Health and Safety Act 2011. HSR's powers are limited to matters that affect workers they represent, except where there is a serious and immediate or imminent risk to the health and safety of members of another work group. A member of another work group asks for assistance and the HSR for that work group, upon reasonable inquiry, is not available. HSRs are only permitted to issue PINs and direct unsafe work to cease if they have completed approved training and consulted the PCBU. HSRs are not personally liable for anything either done or omitted in their role as a HSR if it is done in good faith. With the new powers and duties of various persons under the Work Health and Safety Act, provisions have been made to protect anyone acting in good faith for the purposes of ensuring health and safety in the workplace. The conduct that is protected from discriminatory behaviour under the Work Health and Safety Act includes the activities of persons who are undertaking their role under the Work Health and Safety Act, for example a HSR, directing unsafe work to cease, or a person to cooperate or assist with the direction. A worker providing information to a person who is undertaking activities permitted under their role is also covered. PCBUs should provide support for the HSR and must allow the HSR adequate time at normal pay to carry out their role. Consult and confer with the HSR on work health and safety issues. Allow the HSR access to information about hazards and risks at the workplace, as well as information relating to the health and safety of workers at the workplace, excluding workers' personal or medical information without the worker's consent. Allow the HSR to be present at an interview relating to work health and safety issues if a worker consents. Provide the resources, facilities and assistance that are reasonably necessary for the HSR to perform their functions. Allow any person assisting the HSR access to the workplace as necessary. Permit the HSR to accompany an inspector on an inspection. Grant 5 days initial training for the HSR if requested, with the training provider approved by Safe Work New South Wales, and grant a 1-day annual refresher training if requested. Businesses, employers or other PCBUs must notify Safe Work New South Wales of their HSRs and Deputy HSRs online at the HSR register on our website. If the HSR represents a work group that carries out work for other businesses as well as yours, you can share the HSR's training and other costs. You must display a list of the names of the HSRs and Deputy HSRs at your workplace. The majority of members of a work group may remove a HSR by making a written resolution that the HSR should no longer represent their work group. When a resolution has been made to remove a HSR, a representative of the work group must, as soon as is practical, inform the HSR who has been removed, inform each PCBU where a worker in the work group works, and take all reasonable steps to inform all members of the work group of the removal. The removal of the health and safety representative takes effect when the persons referred to, a majority of the members, have been informed. A HSR may also be disqualified by the Industrial Relations Commission, otherwise known as the IRC. Any person may apply to the Industrial Relations Commission to have the HSR disqualified if they are adversely affected by a HSR improperly exercising a power function, or improperly disclosing any information obtained in the role as a HSR. The regulator can also apply to the IRC to disqualify a HSR